Salutations, respected viewers. This is George from Ireland. I'm carrying on my series about English law and looking at tort, particularly an area of tort that I find scintillating, and that's libel. So what is libel? Well, libel is if a defamatory statement is published to a third party. So it's more serious than defamation because of the permanent nature of it. So writing the defamatory statement is not liable as such. It's only actualized as liable when that's shown to a third person. It could be written, it could be published, and so on. I'll go into what actually counts as publication in a minute. Supposing that Delia says that Edward has hepatitis and it's a contagious disease, and then Delia writes a statement to that effect and shows it to Felicity. Delia has libelled Edward, unless, of course, she can prove that what she said was true. It does not behove Edward to prove to the contrary, because she was saying that Edward had a disease that he could pass on to other people, which might cause him to be shunned or avoided, all the rest of it. Delia, when she showed this statement to Felicity, she was publishing it, even showing it to one other person is publishing it, because Delia is a third party, as in the first two parties are Delia and Edward, the person who wrote the statement, and Edward, the person about whom the statement was written. So that's it. Now, publication includes printing in a newspaper or magazine, publishing in an online forum, broadcasting on television or radio, performing on stage, even though that's not permanent on stage. Now, saying yourself on the street is not libel, that's slander. Right, so that's that. I mean, things that are on stage are sometimes filmed, but even before they were filmed, that was still considered libel, not slander. Now, and there have been cases where things have been published online which damaged somebody's reputation, which couldn't be proven to be true, but it only had a handful of hits, and occasionally courts have said, come on, that was seen as so few people. No, that's not libel. So although in principle showing to even one person is libel, if very few people saw it, a court might rule that that's insufficient. Putting a notice up in a shop window, making a defamatory statement about somebody, that's also publishing it. Right, there are certain exemptions to these overall rules. The media are permitted to report the proceedings of any legislature, anywhere in the world, parliament, local council, anything like that, so long as the reportage is fair. The same goes for court proceedings. So there's qualified privilege, where it's only if you're doing it in good faith and all the rest of it, fair and balanced. That's why often at the end of a court report they'll say the case continues, so and so denies the charges, or you can't say the burglar entered the house. No, you must say the burglar is alleged to have entered the house, all the way through. So, supposing in Parliament Mr. Goodrich says that Miss Horace is a thief, newspapers can report that so long as they said that Mr. Goodrich said that in Parliament. They must use his precise words and not exaggerate. If Mr. Goodrich goes outside Parliament and is asked, would you kindly repeat what you said inside, these slanderous remarks would be slander, unless he can prove what he said is true. Simply to confirm what he previously said inside, it would still be slander. He's no longer got privilege, which he did inside Parliament. And there was a test case of this in New Zealand. Remember when Louise Mensch, Conservative MP, she made certain statements which were disparaging the character of Piers Morgan. He's got no reputation to disparage, in my view. But anyhow, then she was asked on CNN, would you repeat that now you're outside Parliament? And she declined to do so, because she knew she no longer had privilege. She was not in the parliamentary debating chamber. So if she couldn't prove what she was saying was true about him, then she could lose a libel suit and have to pay him very heavy damages. These things have been in the hundreds of thousands of pounds for wrecking his reputation. So anyway, right, in court there's privilege as well. Supposing in court a barrister, Miss Indrajit, says to the defendant, Mr. Jarndyce, you burgled the house, didn't you? The barrister has not committed slander. Miss Indrajit does not need to prove what she said is true. Lots of people have heard her say it. All the same, she doesn't need to prove it's true. If the court finds Mr. Jarndyce not guilty, Miss Indrajit is still not open to a libel suit or a defamation suit, slandering him because it was said rather than published as such. because in the courtroom there is privilege for lawyers, judges, witnesses, and so on. This does not mean people are allowed to lie in court. They're not. There's perjury. But what you say in the course of testimony, even if it trashes somebody's reputation, that has got privilege. They can't be sued for libel, so long as they say in the courtroom during court proceedings. If they were to go outside and repeat the very same thing, then they would be open to these defamation suits. So there is absolute privilege for these statements in courts or legislatures. There's qualified privilege for the reportage thereof. Privilege, it comes from the Latin words here, privileges, private laws, as in this is a particular area of law where the general rule doesn't apply. It doesn't mean privilege as in being particularly advantaged or wealthy or something. So privilege is here because it's an exemption from the general rule. Supposing Mr. Calms is in the Jamaican Parliament and he said, Miss Lambert is a total failure as a dentist. Can a British newspaper report that? Yes, they can, because there is qualified privilege to report what is said in any legislature anywhere in the world. So long as the newspaper reports it in good faith and they report it accurately, they are safe up to a point. So also statements of opinion are permitted. That's why newspapers often distinguish between opinion and reporting the news. They'll often have a page that will be labelled comment or opinion. All right, so you must be representing something as fact, like she is bad, that man is nasty. You're allowed to have these opinions and say things which are disobliging about people. Now, libel does not apply to any very broad or loosely defined group of people. All politicians are shysters. Now, that's not libelous or slanderous because they're such a broad group of people. The British are racist. That's so many millions of people. No, the whole 60 million people can't sue you. So if there's a very large group, it would be daft because that can't be held to apply to particular people. There was a case when somebody said, one of the policemen in that police station, he committed rape. And there are about 10 police officers who worked at that station. There's a fairly narrow class of people, therefore they were able to sue successfully. Or say that a teacher at that school, a male teacher at that school, he molested a child, and there are only a few male teachers. That would be slanderous because there's quite a limited number of them. So anyone could say, this really gave me a bad name. Right, helping the police. You're allowed to say things which help the police speak to someone they need to speak to in the course of their inquiries. Supposing there's a murder, the police suspect that Omar did it. They can issue a description and a photo of him, say that he's suspected the crime. They'll appeal for assistance in apprehending him. That is not libelous. It is not liable to say someone is suspected of crime. It is liable to say that they committed the crime, unless, of course, you can prove that it's true. The police often say, we would like to speak to so-and-so. Put baldly, that means they believe that he did it. They believe this man can help them with their inquiries, as in usually they think that he committed this offence. So the media assist the police by publishing this notice, and Mr. Havers was the Attorney General in the early 80s, and he assured Parliament that the media were entitled to do so, safe in the knowledge that no libel action would be ensuing. And indeed, none has arisen on that basis. And incidentally, because in libel, usually you don't have to say it outright. Implication is strong enough. If you say someone committed a crime, if you saw someone commit a crime with your own eyes, it would still be libelous to say that, because your testimony is not alone enough to prove that he or she committed it or didn't have a lawful excuse. The media, therefore, won't say Nora robbed a bank. They will say she's alleged to have robbed a bank. Now, okay. So, if in reporting trials the media says someone pleads not guilty, that's what they say, that kind of thing. And implications enough. I can't remember who they hinted, saying, what is he putting up his nose? That's not to be sneezed at. Obviously, the implication was unmissable that this chap was snorting cocaine. That was still libel. Or Lady Sally Burko, she's married to the Speaker of the House of Commons. She wrote on Twitter, why is Lord McAlpine's name trending, innocent face? And that was libel. I think that she was hard done by on that one, because the argument was, the imputation from her statement was that he had committed a grave offence against children because it was a well-known rumour at the time. There we are. I think it was too broadly interpreted. Beware only those who breathe. That's another principle of libel law. The dead cannot initiate a legal action, nor can a person's estate do so. Supposing Mr. Mook dies. Once he is dead, a newspaper can carefully say he was a rubbish bus driver, that he kidnapped people. His children are very insulted by these statements, but there is diddly squat they can do about it. They cannot move a libel action against them for these foul statements. Only a living person can sue. You are not permitted to sue on behalf of your deceased relatives, friends, or anything like that, even if you inherited their property. If someone dies, newspapers often publish accusations against that person, which they didn't dare publish whilst that person was still alive. That's why when Sir Jimmy Savile was called to his reward, a lot came out in the wash. The media published things that they wouldn't have published otherwise. If supposing a man starts a libel action, he dies whilst the action is ongoing, the case dies with him that moment. So what counts as libel? It doesn't have to be an outright accusation. It can be an implication that could be sufficient. Image rather than the words can be libelous. Fictional characters can be libelous if they can readily be identified with a real person. Supposing I said that Donny Strump is a bad man and Donny Strump has sexually assaulted many people. Donny Strump committed adultery with Stormy Daniels. Now, the implication is very easy to figure out that I'm alluding to Donald Trump, and I've assailed this man's character, and he is, of course, a man of the most unimpeachable reputation, and because of an unblemished name, I would have surely dragged his name through the mire, so would have to pay him ruinous damages. The internet and so on, search engines, social networking sites cannot be sued because they don't winnow out potentially libelous statements. They claim we don't create material, we provide a platform, we don't actually publish it. But there is some argument about that, about Mark Zuckerberg, that he has to put his house in order because so much damaging stuff is getting out there. But then it would be so farewell to social media. Look at criminal libel. The claim is that some accusations are so lurid and so grossly insulting that they would incite violence. The hot-blooded would be forced to do something about it. It's not the incitement of violence per se. Saying, if I said Mr. Norris is a disgusting pervert, next time you see him, punch him, that will be incitement to violence. Criminal libel is making accusations which are so viciously cruel that they would result in crime. I've not actually urged someone to commit a crime, but what I said was so gravely insulting that some people would go out and commit a crime because of it. However, criminal libel has probably fallen into abeyance through disuse. Use it or lose it with these things. The word here is probably, since it's not actually been repealed. It's the 70s since someone even started a libel action, a criminal libel action. I can't think when one last succeeded. So there's been no attempted prosecution for 40 years on this basis, and it may well be held to be antique. So it's an archaic law. The billionaire businessman, Sir James Goldsmith, he started a libel action against Goldeneye in the 70s. He was persuaded to withdraw in return from an abject and grovelling apology from Private Eye, this satirical magazine. In the 19th century, it was more common. The Irish writer Oscar Wilde, he found a note pinned up in his private members' club addressing him as a sondomite, meaning sodomite. The Marquis of Queensberry wrote it, but he'd misspelt it, even though he'd been to Oxford. So because Oscar Wilde was gay, he was having a romantic liaison with the Marquis of Salisbury's son, Lord Alfred Douglas, and homosexual acts were a crime in England and Wales until 1967. So Wilde ill-advisedly took out a libel action, a criminal libel action against Lord Queensberry, but several rent boys were going to come forward to attest that they had congress with Wilde. Wilde withdrew his action, the case collapsed, blah, blah, blah. He was prosecuted, he criminally prosecuted himself for gross indecency with males and served two sentences of 2 years penal servitude. We have the Ballad of Reading Gaol as testament of that, so we can thank Wilde for being so rash to launch this action. Otherwise, we'd never have such gem of literature about that tent of blue that prisons call the sky and the love that dare not speak its name. So, Wilde was prosecuted by E.H. Carson. They've both been at Trinity College Dublin together. The man who more or less partitioned Ireland, Edward Henry Carson. With all the added bitterness of an old friend, Wilde said that's how he was prosecuted. So to begin with, Wilde ran rings around Carson. He loved playing to the gallery because he was a playwright and a renowned wit and raconteur. So Carson says, "Did you kiss the boy?" And Wilde said, "Oh, no, I didn't. He was very ugly." Carson says, "That means if he wasn't ugly, you would have kissed him." And Wilde was stumped. The trouble was the accusation was true. As I said, Lord Queensberry could prove it. There are many witnesses who would testify to the fact that Oscar Wilde was actively homosexual. Anyway, that was that. Okay, that's enough for the moment.